Very good. I'd like to welcome everybody to the I-29 Moo University Dairy webinar series. The Moo University is a collaborative of the state dairy specialists along the I-29 corridor. We started this webinar series a year ago to address current topics that come up during the year, and we are in one of those topics right now. With the passage of the Inflation Reduction Act, we discovered that there are some portions of that that will in fact affect farmers and dairy producers. And we are excited to have Mike Zahrt make the presentation on that subject today. Mike is a business and estate planning lawyer in Grand Rapids, Michigan, office of Foster Swift, and is the current leader of the firm's Agri-Business sub-practice group. Mike works on a variety of agriculture and cooperative law matters, and he's reviewed the Inflation Reduction Act and has identified areas that producers need to be aware of. Mike, welcome to the I-29 Dairy webinar series. The podium is yours.
Hey, thanks, Fred. Thanks for having me. Appreciate the opportunity. Thanks to everyone that registered too. I know it's a busy time of year, and to volunteer to listen to a pointy-headed tax lawyer in Michigan talk about tax stuff during lunchtime is a commitment that I appreciate. So thank you very much for that. We are talking about the Inflation Reduction Act. It was signed into law about 2 months ago, and since that time, with the exception of yesterday and today, actually, there hasn't been a lot of activity. So I've got a little bit of recent events for you, but more so just kind of picking apart pieces of this monster legislation that would apply specifically to agriculture. So a couple disclaimers before I get started. What's a good business lawyer without plenty of disclaimers? I caught a cold bug over the weekend. I completely lost my voice on Monday. It's nearly back to normal today, and I've been purposely avoiding my coworkers all day to have enough vocal cord stamina to get through this, hopefully. So we will find out about that together. I also have, I don't know if you heard it just then, we recently exercised the option on the lower part of our building to make room for more lawyers, and apparently they're blowing out walls today. So if you can hear the background noise, I apologize for that too. I'm told it will be kept to a minimum. So with that, let's get started. Fred did a good job introducing me. We don't need to talk about me much more. Our firm is a Michigan law firm. We have 5 or 6 offices across the state of Michigan. I lead our agribusiness practice group. It's a full service practice area. So we do litigation, environmental, transportation, tax planning, succession planning, you name it, we do it. I don't do all of it. My niche area is in federal taxation and business succession planning. So what brings me great joy is passing farms along to the 2nd, 3rd, 4th generation of farmers and stiffing the federal government on estate taxes while we do it. Do a variety of other things too, outside general counsel work for various farm clients. Michigan is a very diverse agricultural state. So my biggest clients are dairy producers, probably followed by grain and hogs, turkey, there's some fruit, some fiber. My partner, Todd Hoppy, is one of the best co-op lawyers in the country, and he yanks me in on some stuff too. So I get a little co-op exposure here and there. So that's me. A little housekeeping before we get started. We do have the chat box open, so feel free to put questions in the chat as we get going here. If I think I can get to them in context without getting off the rails, I will. Otherwise, we'll save them for the end and try to get to them then. I do try to save about 10 to 15 minutes for questions when we get to the end. In practicality, I usually ramble and it ends up being maybe 5 minutes, but we'll try to get to as many as we can at the end there. If there's a question that you don't feel comfortable asking to the group, I'll put my contact information on that last slide. Feel free to call me, send me an email. Those do go into the non-billable pile, so they might not be on the top of my desk, but I do make a good effort to get to every single one of those questions. So please feel free to do that if you think of something after the webinar, but I'd be happy to chat with you if you'd like to reach out. And then third, this is a tax presentation at lunchtime. So usually I like to speak in person and I get the little lapel mic and I can run back and forth to try to keep the energy up a little. Obviously we can't do that over Zoom. So I will try to, stay in frame and still keep the energy up, even though we are talking about the federal tax code here. So I guess last disclaimer is that if you are in the cab today watching this, I know John Deere said they're rolling out the fully autonomous stuff at this fall here where you don't even have to be in the field, but pretty sure all the old ones require you to be in the cab and awake if you've got auto track engaged. So final disclaimer there. With that, let's get into the Inflation Reduction Act. This was signed into law on October 16 of 2022. This is Build Back Better 2.0. So if you remember all the conversations about Build Back Better and all the fruit baskets and thank you cards we sent to Senator Manchin for making that drive off into a ditch. This is the next iteration of that. So the complaint was, Build Back Better is over $1 trillion in legislation. It's too big, it's too bulky, it's too onerous on the middle class. We need something that's not as big. So we have this, very slender $739 billion spending package that sprawls over, I think it was 755 pages when I printed it. So it's another one of these monster reconciliation bills. We've seen a bunch of these over the last few years. And later on in the presentation, I'll give you a little more history on what exactly goes into a budget reconciliation bill? How is that different from normal legislation? Because this does seem to be an increasingly common tool for Congress to jam through these big expense packages. And the benefits of reconciliation, if you're the party in power, is that you don't need that 60-40 vote to override all the Senate rules. You can push things through, no filibuster, limited debate time, 50-50 vote. So like this one passed 50-50 in the Senate, and Kamala Harris passed the deciding vote, to pass it into law. So a little easier to push through. Of that $739 billion, we have about $40 billion allocated to agriculture. So before we get into it, I actually had a client email me and say, hey, the Inflation Reduction Act, does it actually reduce inflation? And the answer is, probably not. I've seen a lot of analysis. The most friendly analysis to the bill seems to indicate that it's not going to immediately help inflation, but it might help inflation in the long run. I think what this is more appropriately called is like the Targeting Price Control Act, or something along those lines. If we think of inflation as the spending power of a dollar, and not purely as a function of how much do things cost, this bill's not going to reduce inflation. One of my favorite think tanks, if you're a tax nerd like me and a federal deficit nerd like me, is Tax Foundation. Taxfoundation.org is they hold themselves out as a nonpartisan think tank. I think they're kind of right center. But I pulled their numbers on this, and they project it's going to reduce GDP by 0.2%, reduce wages by 0.1%, and result in the loss of about 30,000 full-time jobs. So that's probably going to have the effect of actually increasing inflation if we're to believe that analysis. But there is some good things in here for agriculture, and we'll talk about that right now. So here's what we're going to talk about today. I guess just a little more background on me. I am from Grand Rapids. I'm a Calvin College grad. For all of you Iowa folks, it's kind of like Dort, just in Grand Rapids. Calvinists are known for like two things, right? Their doctrine of total depravity and a good three-point sermon. I usually think of total depravity when I'm dealing with the Internal Revenue Service, but here's the latter I have for you today, a good three-point sermon. And what we will cover is free money, and all the conservation grant programs and whatnot that got allocated in that $40 billion. After that, we'll find out that free money wasn't free after all, and there are some higher taxes involved. The primary funding mechanism for this bill are the monster corporations, targeting the Apples and the Berkshire Hathaways of the world with a minimum corporate tax. But there are some rules in here that will impact the middle class and farmers specifically through this excess business loss rule. So we'll talk about that second. At the end, we'll talk about changes to the investment tax credit. They have expanded the facilities that qualify for that tax credit. One of them includes biogas digesters, and we've seen an uptick of that lately. They seem to have figured out how to actually cash flow these things now. So that is what we will talk about at the end. So with that, let's get started. First and foremost, these conservation programs. So this is this $40 billion, and this slide breaks down how the first 20 million of this is allocated to various USDA conservation programs. So you've got $1.4 million to agricultural conservation easement, program. You probably heard about these. All these are not new, right? So we're not going to talk about them in huge detail. It's all stuff that shows up periodically in the Farm Bill, programs that get renewed with additional Farm Bill funding. So not new concepts here, just more money thrown at them. But we'll talk a little bit about each of them. So the conservation easement program is just that. The United States government will pay you to enter into a conservation easement where you agree to keep your land the way it is and only use it for certain limited activities such as agriculture. There are various restraints that you can see in a conservation easement. They're not one size fits all. They can actually be a pretty useful estate tax planning tool as well. It creates deductions against the estate tax, and those easements can also have the effect of lowering the value of the underlying asset, thereby lowering your gross estate for estate tax purposes. So it can be a helpful tool, especially if you find yourself in the taxable estate category. This year, that's a net worth exceeding $24 million, which sounds like a lot, but I've seen what land prices are doing, especially in the Dakotas, and it doesn't take that many acres to get to 24 million these days. So beware of that. I've got other tricks I tend to use for estate tax mitigation before I look at conservation easements, but it's a perfectly viable tool. And we've got an extra 1.4 billion allocated to that. The next is the conservation stewardship program. We've got 3.25 billion allocated to that. These are kind of shorter term contracts that you entered into with the USDA, and the whole purpose of the contract is to decrease your baseline level of conservation. So the USDA publishes these conservation standards, and they will enter into contracts with you to essentially give you grant money to do things such as more specific planting schedules, cover crop rotations, no-till practices, drought preventative items, things like that. And again, these are contracts that you enter into. You get some grant money to help you introduce them, a little shorter term and run. It's a very similar program. The Environmental Quality Incentives Program gets the biggest chunk of the pie here at 8.45 billion. Kind of similar to CSP above. These are longer contracts, usually starts at 5-year terms, can go up to a 10-year term, but very similar goals, cover crops, drought prevention programs. You work with the USDA to develop these things, and as long as you stick to the plan, they'll pay you to help implement some of these conservation practices. So a big chunk of change available there. The last being the Regional Conservation Partnership Program. So the last Farm Bill authorized up to 15 of these projects. They've already been kind of identified, and the project leads are kind of often running various USDA critical conservation areas, and depending on the critical conservation area that you're in will determine the programs specific to that region, and the programs that are available for you to participate in. So what this program does is it identifies the project lead, allocates money toward a project, and then you kind of contract in as a subcontractor to achieve these conservation program goals. And same thing, there's grant money available to you to help you implement them. Now you're going to do some math here, and you're going to say, Mike, 1.4 plus 3.25 plus 8.5 plus roughly 5 doesn't quite come out to 20. And you're right, there's other miscellaneous programs. And my favorite administrative expenditures that also get funded by this. So we're going to have more government employees and more money allocated toward these governmental bureaucracy, and we'll probably keep it at that. They've told me not to be too political, is the advice my marketing folks give me. So we're going to stick to it. Keeping the pace moving right along here. So we talked about 40 billion being allocated. We just talked about the first 20 billion. Here's how the rest of it kind of shakes out. So we've got, boy, I don't know if you can hear that. I'm sorry for all the pounding. We got 14 billion for rural energy infrastructure. Most of this, 9.7 billion of this, is allocated to electrical cooperatives. And what we're really focusing on here is rural power producing cooperatives. What they want to accomplish here is we're going to partner this with the investment tax credit. And we're looking at solar, we're looking at wind, and we want to put this on a utility scale, not just an individual use scale. And we're going to give you additional funds to power these rural cooperatives as kind of alternative energy investment. So if you're interested in building a rural energy cooperative, there are funds available for up to 25% of the project cost, capped at $970 million per cooperative. That sounds expensive, but when you figure $1 per watt or $3 to $4 million per wind turbine installed, you're going to burn through 970 pretty quick when you get up to utility level scaling. So they were pretty intentional about this. I will be curious to see the extent that it gets implemented with that investment tax credit to do what they want it to do. There are more renewables in the rural energy co-op space, but still over 50% of those are coal and natural gas co-ops, right? So we're still kind of in the fossil fuel arena there. So we'll see if this does what they want it to do. But if you're in an area where a rural power co-op makes sense, there is additional funding available for you there. $4 million for drought relief. This is almost entirely allocated to the Colorado River Basin. So we're a bit east of that. If we have viewers that are over there, just beware that that's out there. There's $4 billion allocated to drought relief for those folks. 19.5 billion to the Natural Resource Conservation Service. This is the arm of the USDA that implements all of their conservation programs. So if you are a participant in these conservation programs, you're already likely working with NRCS. This about doubles the prior funding under the most recent Farm Bill. And it's not just to fund administrative expenses, right? This isn't just $20 billion for government employees. This funds all of those programs. And what's really interesting to me about this is that it funds the existing Farm Bill programs. So all those programs under the last Farm Bill essentially get a doubled amount of funding. We don't have guidance on how that gets administered. There's this little phrase that appears a lot in the 755-page regulation, and it's implemented by regulations to be published at a later date by the Secretary of the Treasury, right? And all that means is, here's the general idea, what we're going for. The IRS is going to publish some regs telling us how we're going to implement it, or Department of Ag or Energy or who have you. We're going to kick that can down the road and wait for those regulations to come out. And no one's published anything yet. So we don't have a ton of guidance on how this gets allocated. But the reason that I flagged this for you is because the current Farm Bill is up in 2023. So next year, we're going to get a new Farm Bill, right? And it's going to be really interesting to see how this 19.5 impacts that Farm Bill, because the language of the Inflation Reduction Act funds these programs in the last Farm Bill, but permits expenditures through 2031, which obviously exceeds the current Farm Bill. So, things like if you're in an environmental quality incentive program and you entered into a 10-year contract this year, the money that was allocated in the Inflation Reduction Act would be available to fund that almost throughout the entire 10-year term of that contract, which I think is what they're going for here. But the lobbying effort for the next Farm Bill will be really interesting because there's certainly going to be some arguments that, hey, we just allocated $19.5 billion that's available through 2031 for the next Farm Bill. So keep an eye on that if you're involved in lobbying efforts and you are involved in those the Farm Bill provisions, and you keep an eye on that, and every time that it's up for renewal, that's something you'll certainly want to keep an eye on. Obviously, the ag space is going to want to kind of ignore the Inflation Reduction Act for the most part, because this is supposed to be a targeted, limited run program. So that next Farm Bill should just be like the last one. Should be ignoring, but that's out there, and it's something that we should keep an eye on, see how that dovetails with this legislation. If you thought we were out of free money, we're not. But wait, there's more. My little telemarketer pitch there. We've got about $5.5 million in debt relief and financial assistance. And if you think $5.5 billion in assistance in this arena sounds familiar, it's because just last year in the American Rescue Plan, that was that kind of second round COVID relief package, there was about $5.5 million allocated to farmers of color who have experienced discrimination before. So we'll kind of get into the history of this here, but here's what's in the Inflation Reduction Act. So we had the American Rescue Plan, that's a 2021 legislation, called for debt forgiveness to farmers of color, essentially, plus a 20% premium for discharge of indebtedness taxes. So it's not just we're going to forgive your taxes, but if you have discharge of indebtedness from that forgiveness, we're going to kind of fund you for that too. So it's truly a no-cost thing to wipe out your tax debt. Almost immediately, that got held up in legislation, right? All the farmers that look like me said this is reverse discrimination. White guys are just not eligible for this legislation. And it's discriminatory. And that never wound its way through the courts. I think the Obama administration, or excuse me, Biden administration looked at that and said, you know, this is going to be more hassle to fight. It's going to take so long to work its way through the courts. Let's just axe it and try again. And that's what they've done here. So now we have $3.1 billion to distressed borrowers. And you see the $2.2 billion to farmers that have experienced discrimination by the USDA's lending programs in the past. You know, we're calling these socially disadvantaged farmers. So it kind of takes the racial qualifications out of it. It'll be interesting to see how they implement this. Again, this is implemented by regulations to be prescribed by the Secretary of the Treasury. So we don't have any guidance on this stuff yet. And we're almost 2 months in, right? So who's a socially disadvantaged farmer? We heard the rhetoric about, you know, new farmers. So if we have second, third generation farmers that want to strike it on their own, their family may have been in ag forever, but they would qualify to, you know, get them on their feet and off the ground as they start their new venture. It might be women in ag, because that is certainly a minority group when we look at typical demographics of agriculture. So, you know, that money might be available for a broader pool than the old money, and that's kind of the way it's supposed to work. We've got nothing on that yet. What's interesting, and this is the fun new stuff, right? So it's been about 2 months since this legislation is passed. If you go to the USDA website, there's a paragraph on conservation programs. There's a paragraph on debt relief and financial assistance. And it's just check back here periodically and we'll publish updates. Well, 2 months later, we've got no updates. So what we've got here is just yesterday, there was a class action lawsuit filed against the United States government by a group of farmers of color. Ben Crump is the attorney that filed that lawsuit. If that name rings a bell, it's because he's the guy that does a lot of other class action stuff and racial discrimination. So, you know, heavy hitter in this space, certainly someone to be taken seriously. And that lawsuit alleges a breach of contract by the U.S. government for repealing that $4 or $5 billion that was promised under the American Rescue Plan. So the argument is, hey, it was COVID. You wanted to shore up our food supplies. We did that. We bought more equipment. We planted. We might have gone even farther in debt based on these promises for debt forgiveness, and you pulled the rug out from under us. So, you know, call it a coincidence or not, but just so happens this morning, the USDA said that they were ready to receive public comment on this $2.2 billion discrimination package. And we'll continue to accept comments for the next 30 days. So individuals, industry groups, what have you, can comment and say, this is how we think this $2.2 billion should be deployed. And near the end of that term, they will actually publish some regulations that, well, they'll be proposed, so they'll tweak them some more. But things are finally in motion. As a lawyer, it just made me smile, because no matter where you find yourself on the political continuum here, the lawyer in me just laughed and said, sometimes you just got to sue somebody to get stuff started. So that made me chuckle. There's your breaking news. The only new thing that I'm aware of in the last 2 months is that. So the socially disadvantaged farmer relief is in motion. I have seen the comments from the various committees that looked at this, and it was very intentional that socially disadvantaged farmers includes more than just farmers of color, right? Because that was the whole constitutional issue that got tied up in the American Rescue Plan. So it should include women farmers. It should include new farmers. It should include farmers that live in a community that is typically below the poverty line, or farmers that maybe live in advantageous communities, but they themselves are below the poverty line. Indigenous people, you know, just, you know, what we're trying to do here is encourage people that don't look like me to get into farming. And that's the whole purpose of this legislation. So hopefully the regulations will be implemented accordingly. There's certainly going to be more applicants than there are dollars. So last time I checked, there's direct USDA loans and there's guaranteed USDA loans, right? So the guaranteed USDA loans is the federal government itself is loaning you that money. There's about 15 billion of that sitting out there. Distinguish that from USDA guaranteed loans, where there's a private lender that actually disperses the money, but the USDA stands in the background and says, okay, if they default, we'll guarantee it. There's another 19 billion of that out there that is all eligible for this debt forgiveness program. So, I mean, you're sitting on, boy, you know, $34 billion in loans, and we'll got enough money to forgive maybe 10% of that. So Obviously, most people who do these applications for USDA loans might not be distressed farmers. They might not be socially disadvantaged. So that should winnow the field pretty quickly. But if you find yourself in that space, and again, it could just be that you're a woman in agriculture. It could be, grandpa farms and dad farms, but you want to go out and do your new thing. If you're a new farmer, you might be a socially disadvantaged farmer. This is certainly something to keep an eye on in the next 30 to 60 days, is hopefully we get this stuff rolled out. So keep an eye on that. One more note, this $2.2 billion to farmers who experience discrimination by USDA lending programs. This isn't so much of a conceptual thing as much as following up on previous administrations. So the Obama administration faced some legal scrutiny over this issue as well. There was a finding of discrimination, and the Obama administration paid out $1.25 billion as a settlement in connection with that. So this is kind of a recognition that that prior settlement agreement probably didn't go as far as it should, and that's why we've got the $2.2 billion on top of that. So again, keep an eye on that. That's what they're looking at now over the next few days. So we are doing a good job. We're about halfway through, and we are done with free money. And not surprisingly, the free money is not free. We've got to pay for all this stuff. And the reason we have to pay for all this stuff is because this is a budget reconciliation bill. And I think it's important that we understand how those reconciliation bills function, because it's been such a tool of both, Republicans and Democrats recently to get their priorities through. So with that, I will talk about the reconciliation process. I'm going to have just a little bit of vocal cord lubricant here. Continue. Well, you can see my mug. They told me not to be political. I can't help it. So again, we talked about budget reconciliation being an easier way to pass stuff through the chambers. It's not a new thing. It seems like it is, but budget reconciliation has been around since 1974. It's been used 23 times in the intervening years. Notable ones are those drastic deficit spending cuts under the Reagan administration. The Bush tax cut packages in 2001 and 2003 were both reconciliation bills. That big Trump tax reform package, the Tax Cuts and Jobs Act in 2017, budget reconciliation, the American Rescue Plan that we talked about a couple slides ago, reconciliation package, and now the Inflation Reduction Act is budget reconciliation. So both parties have used these. They usually use them for big ticket legislation. And the reason is, again, because you can send these things through a lot quicker. But there are some rules. It seems like it's the Wild West when you get 755-page legislation. But there are some rules. There are certain things that you just can't talk about during budget reconciliation. And there are certain things that we're going to limit you to one bite at the apple per year. So spending, revenue, these big picture categories, you can't pass two revenue reconciliation bills in the same year. And obviously a revenue reconciliation bill being tax hikes, right? That's how we get more revenue for the federal government. So the idea being you only get to hike taxes once with a reconciliation bill per year. What we've seen in the Biden administration is when they first got elected, back in 2020, you had Bernie doing his thing with, really throttling down the estate tax, and we're going to eat the rich and all this stuff. And it didn't get anywhere because you kind of have a fractured Democratic Party. And because you only get one bite at the apple, instead of taking those progressive bites every year for a 4-year term, they want to jam everything into one reconciliation bill and get everything they want. And you get the Senator Sanders over here and the Senator Mansions over here, and they haven't got as much done as perhaps they wanted to for controlling both chambers and the White House. So that's a little background for you. Reconciliation also requires compliance with the Byrd Rule. The Byrd Rules, we typically just hear it on the news as budget analysis. The Byrd Rule's got a lot of things in there about how you can name these things and other stuff. But what we want today is the budget portion. So the idea of a reconciliation bill is that it cannot increase the national deficit over the reconciliation window. And we saw this in the Tax Cuts and Jobs Act too, where the Trump administration had this, big sprawling tax cut package for everybody. And you kept hearing, well, failed budget analysis. And so they kept tweaking it and adding all these little hooks and carve outs and these quirky little rules that didn't really make sense from a traditional Republican perspective until you took a step back and said, okay, they're projecting this over a 10-year reconciliation window and it's losing money. We got to pack a little more revenue into this thing to get it to pass. And that's how you come up with this kind of quirky stuff. So with that background in mind, we're going to get into the excess business loss rule, which is Really, the only tax hike measure that impacts agriculture under this legislation is primarily funded through this $15 million corporate tax, or 15%, excuse me, on those with profits of over $1 billion. So again, it's profits over $1 billion. We're looking at the Apples and Berkshire Hathaways of the world. That's the primary funding mechanism for this. But we do have this excess business loss rule. Before we define that, I think it's important to talk about net operating losses because the two dovetail together. And NOLs used to be this thing that you just kind of set it and forget it, right? And then between the Trump administration, the Biden administration, and COVID, it's just been tumultuous to keep track of what's going on with net operating losses. So we'll do a little brief history of tax stuff. If you're in the cab, take a sip of coffee, stay awake. We're really getting into the weeds on some tax stuff here, but I think it's important. So old NOLs really made a ton of sense, right? You could carry them back, you could carry them forward. And the idea was if I had $1 million loss last year and I've got $1 million in taxable income this year, I carry forward my $1 million NOL and I wipe out my $1 million worth of taxable income. And you could carry them back 5 years, you could carry them forward. And it just kind of made sense. So when we were looking at the provisions to the Tax Cuts and Jobs Act, all the revenue that we were losing by throttling back the corporate rate to 21%, creating that new 20% 199A deduction for pass-through business owners and a few other things that we did, we had to come up with a little bit more revenue. And the compromise that was reached was net operating losses. So the proposal in the Tax Cuts and Jobs Act was that, okay, now dollar for dollar is gone. They're worth 80 cents on the dollar. So if I had $1 million loss, $1 million worth of taxable income, I can't just carry that forward and wipe it out completely. Instead, I can carry forward 800,000 and I can wipe out 80%, but I'm still paying tax on 200,000. The remaining 200 NOL gets carried forward into next year's and I can keep whittling away at it. But you can see what that does, right? It forces the acceleration of income into earlier tax years. It defers deductions, increases revenue, and helps it pass budget. It did some other things. So for everyone but farmers, there was no more carryback. You can no longer amend a prior tax return where you had a good year and then the next year is a bad year, and let's amend that return to wipe that out because you don't want to see what happens the next year, right? Let's just take the bird in the hand and get a little back on that return. If you're not a farmer, you can't do that anymore. The reason I mention that for this group is because it's not just, do you identify as a farmer, it's farm income, right? So if you've got non-farm income and you're looking at your NOLs and what you can carry back and what you can't, you got to distinguish between, is this a farm NOL or not, because that determines whether you can carry it back or not. Farmers can carry it back 2 years instead of 5. And we shorten that window where you can carry back unlimited carry forward. Again, treat them separately. So that was supposed to be the Tax Cuts and Jobs Act rule. Well, it was supposed to, come in 2018. Well, then here comes COVID, right? And now people are just getting crushed by everyone being shut down during the pandemic, and we're trying to throw people a bone here. So the CARES Act comes in 2020 and retroactively amends the Tax Cuts and Jobs Act that says, that 80% rule, and that excess business loss rule, we're not doing that. We're going to get through the pandemic and then we'll turn those rules back on. So you had people amending their tax returns, taking the full dollar for dollar. And then in 2021, so just last year, was the first year where you got the 80 cent on the dollar NOL rule. So it really kind of shook things around a little. We're going to change the NOLs. Then we lived with that for a little bit. And then the CARES Act came in and said, we're going back to the old rules until 21. And since 21, things have kind of been where they're at now. So for farmers, NOLs are worth 80 cents on the dollar. You can carry it back 2 years, unlimited carry forward. And if you've got non-farm losses, you've got to make sure that you're segregating those out so you don't inadvertently carry them back when you're not supposed to. That's the state of NOLs. They're not as good as they used to be. I give you all of that history so we can better understand the excess business loss rule. This was a brand new creature of the Trump administration, and it applies to all non-corporate taxpayers in addition to other limits on uses of losses, and I'll get grumpy about that in a minute. It's my least favorite rule in the entire Internal Revenue Code. I hate this rule with every fiber of my being. It accomplishes no tax purpose. It does not make sense conceptually, and you'll see why here in a minute. Its sole purpose was we did all this frogging around with the NOLs to get the Tax Cuts and Jobs Act to pass budget, and it didn't pass budget, right? We needed a little bit more revenue. But NOLs were such a hotly debated item that we couldn't make those any worse for taxpayers. So we had to come up with something new to accelerate revenue into sooner tax periods. And that's where we created this excess business loss rule. It was supposed to sunset in 2025. We had the American Rescue Plan, they kicked it to 26. And then when we looked at the deficit that would be created by the Inflation Reduction Act, they looked at it and said, well, without extending this rule again, it's not going to pass budget. So that's what we have now. We have an excess business loss rule that's now set to expire for 2028. And if I'm a betting man, we're going to keep having monster reconciliation bills that are going to increase the federal deficit. And this will just be a nice little string they get to pull and say, hey, we're going to extend it to 2030 and 35 until eventually it just becomes a permanent fixture of the tax code. Now that I'm off my soapbox, let's see how this thing actually works. What it does is it limits your business losses to an amount that is indexed for inflation. So initially this was $500,000 for married filing joint taxpayers. It's 540 this year. Inflation's going crazy, so it's going to be more than 540 next year, right? It's going to be big. And the idea is that it limits the losses you can do in this year, and it forces you to carry that over into an NOL in the following years. And we just talked about how net operating losses aren't as good as they used to be. So not only does it force you to recognize more income in the current year, it turns it into this tax attribute that's not so great anymore, and it's still fine, but it's 80 cents on the dollar, right? So that's the whole purpose of this rule. And let me just give you a little illustration here so you can see how this works. So an excess business loss is defined as the excess of, so the amount of losses you have in excess of your aggregate trade or business income, and that's an important term, over your aggregate trade or business, your aggregate deductions in excess of income plus a threshold amount. The threshold amount is that $540,000 that's indexed for inflation. So if I make $1 million in business income this year, but I have deductions of say $1.6 million, I apply that rule and I say, well, I've got 1.6 million in deductions minus my $1 million of income minus my $540,000 in threshold amount. That gives me a $60,000 remainder. My excess business loss is $60,000. So I'm running a loss for that year. So I've already got an NOL. But say I don't. Say I've got $600,000 in non-farm income. So now I've got 1.6 in income. I've got 1.6 in deductions. What the excess business loss rule does is it says, now wait a minute, your excess business loss is $60,000. Even though you've got non-business income of $600,000 floating around out here, you can only offset the threshold amount, right? That $540,000 amount, and you have to pay taxes on that $60,000, and you can take the 60 deduction that's left over and carry it forward in the future years. So pre-Tax Cuts and Jobs Act, that scenario, you'd have a goose egg, right? It all just washes out, and that makes sense, right? Because I've had 1.6 million in income, some from business, some from non-business, and I've got 1.6 million in deductions, but it all funnels through to a married filing joint return, and I've spent as much money as I've made, so my taxable income should be a goose egg. That makes sense. What the excess business loss rule does is it creates this kind of artificial formula where we're isolating business losses, not letting you use them to fully offset non-business income. So you have to pay the income tax sooner and defer the deduction to prior tax years. Again, why that rule frustrates me so much. Excuse me, thank you. So that's the excess business loss rule. And again, this applies to anyone with deductions that are over this threshold. So we talk about how this is not really affecting the middle class. And I guess maybe if you consider that the middle class doesn't have $540,000 in deductions, that's the case. But you go out and buy a new combine and you don't have any taxable income, you're going to hit this. So something to be aware of with your CPA. We used to tell farmers it's fine to run a loss. If you want to prepay for inputs, prepay for fertilizer, prepay for seed, because you're already having a bad year, go ahead and generate an even bigger loss this year because you can use it to offset a good year next year. That's not really the game anymore because you're only getting 80 cents on the dollar, right? So the new game is you almost have to be a little more surgical about it, a little more precise at the end of each year and say, what's my income just for this year? What do I got to do to mitigate just this year? Because you want it as close to zero, but not negative as you can get, again, because those NOLs are only 80 cents on the dollar. So doesn't completely change the rules of the game for income tax planning, but you do have to be a little bit more precise in how you're planning for things, just because of what we've got here in terms of new rules and this excess business loss limitation. So to tie it all together, then the rules that we have for business losses. Again, this is a brand new rule from the Tax Cuts and Jobs Act that gets extended by the Inflation Reduction Act. And I mentioned earlier I'm a Calvinist, and we like 3-point sermons and total depravity and all sorts of other things. So we look for scripture for inspiration from time to time. And when this first came out in 2017, I thought about Jesus being tempted in the wilderness, right? And Jesus was only tempted 3 times before he was attended to by angels. And it was such a beautiful analogy for how a taxpayer has to utilize loss, right? Because we had all these rules. You have to have basis. You have to be at risk. It must be an active trade or business. And, there's your 3. And once you get your 3, you could turn to the IRS and say, away from me, Satan. Now you've got 4, right? So you've got this excess business loss rule. That's in addition to that. Sorry, excuse me. Oh, that cold's hanging on. And the order in which this stuff goes is important, right? So take a look at the order in which we have things here, these requirements. Notice active comes before excessive, and that's important. So we're applying the active versus passive rules before we apply the excess business loss rule. And again, we're segregating business versus non-business income. So something to keep in mind when you're talking to your CPA there. The at-risk rules can also get sticky, especially where you're in a partnership, right? So you can have debt basis in a partnership. And when you have debt basis, things can get a little sticky as to whether or not you're at risk with respect to that basis. And it depends on, do you have partnership guarantees? Is this recourse or non-recourse indebtedness? What's your operating agreement say? So where you're getting into a situation where you're evaluating the need to have debt basis to take deductions, make sure you're doing that carefully, and that you're not going to, inadvertently create a capital account deficit that's now going to trigger, qualified income offset or a debt reduction obligation. These are pointy head tax lawyer terms that we generally like to avoid in partnerships if we can help it. So save this slide, take it with you to your year-end tax planning with your CPA. And when you have deductions, you've got your handy dandy little checklist of, okay, I've got these 4 hoops that I know I have to jump through to make sure I'm going to be able to use all of my business losses as efficiently as possible. This should be at least a good guide map for you. You don't have to remember all the nonsense about recourse and non-recourse. Your CPA should have a handle on that. So we're 2/3 of the way through. We talked about all the new money that's coming out in forms of grant programs. And I do think they're good for ag, and I think they're beneficial to a lot of people, and you should sign up for them. The reason being is because we're all going to be paying for them anyway, right? Through all the excess business loss rule, and maybe go out and buy a new iPhone and thank them for paying that 15% minimum tax if they don't find a way to avoid it, which they might. So with that out of the way, we're going to move on to our 3rd point of our 3-point sermon. This is the investment tax credit. Boy, if you thought we were in the weeds on NOLs, we'll just talk about tax credits and really knock you out with your lunch here. So the investment tax credit is, again, it's supposed to dovetail with the rural energy use, right, and renewables. And what we want to do is incentivize people to build renewable energy sources. That's the whole idea behind this stuff. So they expanded the income tax credit to apply, the investment tax credit to apply to a whole variety of things. So it traditionally already applied to solar and wind, and it still does. But it also applies to biogas properties, which is the big one if you're in dairy and you're kicking the tires on building a digester. So that's what we're going to focus on today. And I think that makes sense. Most of my clients that do solar or wind really just enter into land leases, right, with a developer, and they got an option to use some dirt. And if they exercise their option, the lease price goes up, and that's typically the end of it from a producer perspective. So my office does do that work if you got any questions on solar or wind, but it's usually the digester component where the producer is very involved, right? Because you got to keep delivering manure to the digester to keep the thing running. Just by its nature, it's a more involved project. So we're going to focus on anaerobic dairy digesters today. If you don't know what those are, I'm sure you do, but the idea is it's an anaerobic digester, anaerobic being an absence of oxygen. So what happens to manure is if you spread it on the field and it's allowed to decompose in the presence of oxygen, it's fine. If you put it in a pit and it is allowed to decompose without the presence of oxygen and anaerobic decomposition. It produces methane. And environmentalists do not like methane because it has about 80 times the warming power of carbon dioxide. So what they said is, well, if we can figure out a way to capture that methane, convert it into something that's burnable, and then combust it in other activities that we like, that combustion captures methane, does something useful with it, and converts it to carbon dioxide, and you have a net factor of 80 savings on greenhouse gases. So this is why we like anaerobic digesters. And they're kind of nice. You know, you've got the California Low Carbon Fuel Standard Board, and as long as that board doesn't get defunded, you never know, these, you know, prove valuable. So even before the investment tax credit, we had people that were building these things, right? So you get a developer that comes in and they build it. And either they or somebody very closely affiliated with them will operate it for you, and your job is to deliver the manure. And there's all sorts of ways to monetize these things. I have clients that strictly get paid on a per cow basis, right? Just you bring us some manure and we will pay you for that manure, and you get the manure back at the end of the day. Not as profitable, but it's very hands-off. You're not involved in any of the environmental or permitting stuff. It's just a per cow payment. I have other folks who want to be 100% involved in the operation, and they're going to build it. They're actually going to operate it, you know, co-operate it for the foreseeable future. And you're going to get money for selling that methane, which is kind of small margins on that, but it's something. Plus, you get the tax credits from this California Low Carbon Fuel Standard Board. And all that is there are companies in California that need to offset their carbon footprint. So they'll buy your methane off of you to, you know, reduce their thing. They'll sell you the credits. And that's really how these things have been monetized. So even before the investment tax credit, that was a good way to do things, as long as that money doesn't dry up. The investment tax credit kind of, I don't want to say supercharges it, but those California credits were only after you were in production, placed in service, right? Only once you're producing that methane, selling it into the pipeline, can you get paid the credit for it. Whereas the investment tax credit kind of refunds your investment costs initially. It's all the upfront costs of building the digester. So you get a credit for building the digester, build it for 70 cents on the dollar apparently, and then you get the credit on the back end for the supply agreement, which is kind of a nice way to do it. So that's kind of your 10,000 foot view on manure digesters. Again, you got to be careful with, you know, the California board out there. If they get defunded, you think it'd be a great thing, right? Because methane's 80 times the warming power of carbon dioxide. But you know, you see these kind of armchair environmentalists saying, you know, we're incentivizing people to generate more manure. They're not spreading out in the fields like they should be. You know, we're building these big pits and we're just incentivizing pollution, which is, you know, all well and good if you don't consider, you know, agronomic practices for applying manure and the benefits of, you know, super CAFOs. And, you know, where I live, it kind of gets pretty cold up here and it's hard to apply too much manure when the ground is frozen. So you kind of need a pit for it. So, but armchair environmentalists aside, that's kind of the benefits of anaerobic digestion. What does it do under these new tax credits? So the requirement is that you have to have a qualified biogas facility. Qualified biogas facility is something that produces at least 52% methane or can be treated to produce 52% methane. So you see these, you know, these scrubbers, these treatment things that are kind of tacked on in addition to the digesters that get them to that 52% threshold. Which, as a matter of course, I mean, they kind of coordinated with California on this, right? This is the purity level you need to be able to sell it, get the credits anyway. So this is just what people are typically already producing. But that is a biogas facility, must begin construction before 2025. So kind of a tight window to get going on this stuff if you want to qualify for the credit. And what you've got to keep in mind here is if you're thinking about building one of these, think about how long am I going to own it? What's my exit going to be? And what do I need to do to qualify for this credit? Because we'll see here in a minute, if you're not doing it, if you haven't already started, or if you're not going to build one soon, there's going to be additional costs to get the full credit. And you're going to make sure you're forecasting that, you know, is it worth achieving the full credit if I'm going to spend even more than that just to get there, right? So you got to be mindful of that. Other things you need to be mindful of, though, is are you actually going to hold on to this thing? Because the developer is going to charge you to build it, and they're probably going to charge you a royalty on the gas that it produces. And then you're going to need an operations and management company to come in and actually do the digestion. And they're probably going to charge you a royalty on that gas too. So what you got to think about is, what's my exit? If my exit is I'm going to sell this thing to somebody else and all I'm going to do is supply the manure, and I just want to get cashed out after I've built it, well, that's a different animal, right? You're fine with a little higher royalty on both ends because you're not actually going to be paying that royalty. You're going to be cashed out. And you want to make sure whatever cash out provisions are in that agreement are friendly to you in light of your net return. If you're going to be operating this thing forever, maybe you're willing to give them a little higher exit premium because you don't intend to exit, but you want a bigger chunk of that gas royalty. So begin with the end in mind when you are thinking about building these things. Think about your exit. And that's kind of your negotiation point. There are a lot more in, making sure you're carving off who's in charge of which environmental stuff, permitting stuff, liabilities, and that kind of thing. Compliance with tax credit requirements and indemnification if they do things wrong. There's a lot that goes into building these things just from a negotiations and documentation perspective. But that's kind of your threshold matter when you're looking at, is this a good investment? Think about your exit and how you're going to get out of this thing. Not just the cost to build, although that is important, and we'll see why. So the old investment tax credit was 30%. It's now 6%. But they've kind of done something funky with the formula here that allows you to get back up to that kind of old 30% threshold. And this is an OR test, right? So you got three things here. You only need to satisfy one of them to get back up to 30%. Project output, less than a megawatt, so smaller facility. Again, this is more, electrical, thermals in there, but we're looking at solar and wind primarily on this stuff. Here's the one I think most people are going to qualify for. Construction begins prior to the 60th day following publication of prevailing wage requirements. So again, this is the regulations to be published by the secretary caveat. And we'll get to the prevailing wage requirements here in a minute. But the idea is if you've already built one, are building one, or are going to start building one very, very soon, you're kind of grandfathered in because we're not going to make you gross up the wages for the employees that you already paid to build this thing just to qualify for the credit. So it's kind of a grandfathering. Very generous, very nice. I have a client that is going to qualify for that. It's going to be great because you can back pay wages, but as we'll see, prevailing wages are not cheap. The OR is otherwise satisfy prevailing wage and apprenticeship requirements. So this is kind of you haven't built one yet. You don't get around to it until after they publish the regulations. This is where you've really got to be careful, right? Because your default credit is going to be 6%. So if you got 30 million into a digester, and you're only getting a 6% credit on that. That's more than you were getting before this legislation. So that's fine. But maybe you don't pay prevailing wages. Maybe you pay union wages, right? Maybe you don't have apprentices. You just get the thing built, take your 6%, 6% better than you were. Or you need to forecast, okay, here's what it would cost regularly to build this thing. Here's where my prevailing wage and apprenticeship cost is. And what is that? Is that more than 30% of the original build cost, more than 24% of the original build cost? Because if you're going to eat up your entire credit, just paying other people's wages, that credit isn't very useful to you. And the record keeping and administration that comes along with satisfying the IRS that you've jumped through that hoop is probably not worth the credit. So again, that's where you put that off to the developer and say, if I want this 30% credit, show me the forecast that says I can pay these prevailing wages, I will incur these extra costs, but I'm still going to come out net positive. That's something you really need to be aware of if you don't hit this prior to the 60th day following regulation requirement. We don't have the regs yet. So if you haven't built it yet, but you're going to start in December, you're probably okay. 10% bonus for domestic content, 10% bonus for built in energy community. If you're doing your math along home with me, you're right. This could be a 50% credit, which would be pretty huge. They're hard to get, right? Domestic content means 100% of your steel and iron is US sourced. There are also other component requirements for making sure pretty much everything else is at least, I think, 40% domestic source. Don't quote me on that percentage, but it's significant. Tough to get. 10% bonus if built in an energy community. Energy communities include brownfields, coal areas, so think mountains, or certain areas where a significant portion of jobs and revenue relates to the extraction, processing, transport, storage of coal, oil, or natural gas. If you live in the plains or the Midwest like I do, there's just not going to be that many energy communities. Maybe you'll luck into one. They will make a map eventually. We don't have the map yet. Know that it's out there. For those of us where we're at, know that you probably don't qualify, but it's out there. So if you luck into 50%, awesome. Prevailing wage and apprenticeship requirements. We won't spend too much time on this, just to make sure I leave at least 5 minutes for questions. Prevailing wages are published state by state. It's essentially the wages you have to pay people when you do business with the government. They're significantly higher than union wages, and they actually will break them down by, electrician with this much experience, welder with, different experience levels. It's pretty granular. You want to put that off on your developer, that if you're going to pay prevailing wages and you need to track that, they have to track that, because the record keeping is very onerous. There are apprenticeship requirements. They're not too bad for early construction, as you can see, and then they kind of ramp up for later construction progress. So again, the bottom line for you, if you're thinking about building a digester, know that it's out there. Put the substantiation requirements onto your developer and have them forecast that to you at the front end, so is it worth pursuing that bigger credit, and how much of that credit am I actually going to get in my pocket after I pay these extra wages, right? Because it might just end up being a wash. And again, that negotiation perspective is going to be, what happens if those wage costs, blow through your credit? And now you thought you were going to get a credit, now you're actually losing money. Whose fault is that? You want to make sure that you have kind of those mechanisms in place as you're developing your digester development operations and management contracts. We've got a question here from Heidi. Can you share some examples of where energy communities currently are? So the USDA does have a brownfield map. You can get a map of every brownfield development parcel in the country. So that's one. They're typically metro, right? So Detroit's not going to let me put a digester in next to Kobo, right? It's just not going to happen. So maybe you'll find one that fits, probably not. Coal areas are going to be, think mountains, Rocky Mountains, Appalachians, Smokies. There's a lot of coal communities out there in those mountain towns. So again, pretty limited for where we live. The one that I think we might luck into is that Census Bureau track, and that's the one where we don't have the map. And don't quote me on this, but I want to say it's something like 0.17% of jobs and something like 25% of local tax revenues come from this, production, holding, what have you, of natural gas, coal. So that might be where we can slip in. And again, it's going to be really interesting to see, how big is the census tract? What are we looking at there? I know in Michigan, we do have some areas that have some pretty big underground natural gas storages where there's nothing going on the surface. It's all underground, but that's part of that census tract where we're storing natural gas. So those conceivably could be an energy community, but for the most part, we're talking brownfields and coal. And what we're kind of doing here is throwing an olive branch to the coal producers, right? And saying, we're really kind of hammering your industry and trying to get people to allocate funds away from coal and to renewables. And we want you to do that too. So we're going to throw you a little extra 10% bone to do that instead of coal. So that's that. And we've got 3 minutes. I told you I was going to ramble. I'm sorry for rambling, but we've got 3 minutes left for questions. Feel free to put it in the chat. Otherwise, I don't know how the unmuting works, if Fred's got to do it, or if you can do it yourself. We got 3 minutes left for questions.
People can unmute themselves, so if they want to ask a question directly. I've got one question here. Can these energy communities change? I mean, we've got a community out here that has 6 digesters. It's kind of a growing business. At some point, if we get dense enough, will they become an energy community?
I think they would have to re-up this legislation. So, and it's solely because the income tax and the investment tax credit has a lot of begin construction date and placed in service date requirements that I didn't cover here. But the one that we did cover is that begins construction before 2025. And just the way the census program works, the census tracts works, it seems unlikely that for the current census cycle that we would redefine those tracts to hit an energy community. It's going to be a prior one. Now, if they push this date like they pushed the date for the excess business loss rule, which they certainly could, maybe then you get the next census cycle, you've got the new density, and we've got shifting energy communities.
Okay. Do we have any other questions that folks want to unmute on and ask directly? Otherwise, go ahead and type them in.
And I think, let me advance my slide here. So this is my contact info. It's got my direct office line on there too. So you call that, you won't get the receptionist, you'll get me. If you don't have any or you come up with any later, feel free to reach out.
I've got a question, and my conservativeness will come through in my whatever, but what are the probabilities of all these reconciliation bills meeting their revenue neutral goal? Or do they, who comes up with this revenue neutral goal? So it's more of a global question specifically around this, because it seems like we go in bigger deficit every single year. And so something's not quite lining up in my brain.
Yeah, this is kind of interesting the way they strategize how to build these reconciliation bills, because the budget analysis is really just done in a vacuum of the reconciliation bill, right? So you can go and pass anything else that you want on traditional Senate rules, the 60-40 filibuster breaking rule and that kind of thing, and it can create a huge deficit. Go ahead, which is partially why we see the deficit go up. The other part is that, the Senate, it's the Senate committee that does all this forecasting for budget reconciliation. And what they look at is they just, kind of take things at face value, and they assume that Apple is just going to keep doing business the way Apple's always done business. And here's the revenue we're going to generate from this 15% minimum tax. And what'll be curious to see is how those big corporate giants pivot and say, well, okay, this is based on $1 billion in profit. I'm going to show $990 million in profit, and I'm going to figure out a way to invest in R&D or offshore or you name it. I'm going to hire people who are probably more skilled than I am as pointy-headed tax lawyers to skirt this thing. And I think that's also why these things never really pan out to be true deficit neutral bills, because corporations are going to react. Apple's not going to pay 15% on $1 billion.
We had a question come in asking if the slide deck will be available. This program is being recorded and it will be available. Give us probably till Tuesday or Wednesday next week. They're at the i29muu.com. So yes, it will be available. Are there any other questions coming in? Okay, I'm not seeing any. Michael, this was really an informative hour, posed a lot of topics that hadn't necessarily been considered. Appreciate you being willing to put your contact information up there if folks have questions they want to ask directly. Seeing no other questions coming in, I'm going to say thank you, and we will be closing this program down.
Been a pleasure, Fred. Thanks.
Yep. I'd like to welcome everybody to sign up for our programs every month. Go to i29muu.com, and we'll be having the next program on the 10th of November. Thank you.